So I'm going to talk about cannabis impairment. And I'm going to focus on two areas of impairment. One is the driving, and one is cannabis in the workplace. And what I'll talk about is really updating you on the legislation, enforcement, and implications for driving, and then in the workplace, giving you a sense of what the concerns are, the considerations, and the strategies. And I'm going to bring in some case law, because I find if you have your own company, or if you're an employee or an employer, sometimes understanding what happens when things go wrong makes you realize what you need to do to prevent it from happening in your own workplace. So I'm going to give you some case law, as well as have time for questions and answers. So I never know what kind of bio I'm going to get, so I know that I'd like to fill it in. I'm speaking tomorrow actually on cannabis in the workplace from an employer perspective, because as you grow your companies, if you're not ready, if you haven't created a strong structure, then you're not going to be there past 2019. If you think you can rapidly grow from 0 or from 10 to 100 in 6 months, if you don't have a structure in place, you're in trouble. If you're not going to be competitive, you're in trouble. So if you want to come, I'm speaking tomorrow, and you can see me. So the bio doesn't focus on more the medical part of it, so I better tell you where I graduated from. So I did graduate from the University of Toronto. I got my bachelor's in science and nursing, and then 20 years later, because I wanted to have a state-of-the-art master's, I went back to U of T for my master's in health and science. I am an ICU nurse. I started there with where the action was, and quickly became an educator because I love to teach. Then I became a manager, a director, and I even brought in IT software as our companies, our hospitals became computerized. Then as I was finishing the master's, my husband said, honey, I'm thinking of starting a company. So what became one person one day, and somebody 2 weeks later to pay him, became 125 people in 7 offices across Canada. And we actually believed in creating a great workplace. And by the time we were 10 years old, we put in information to be assessed, and we became one of the top 10 best workplaces in Canada. And we did that twice, so I think that's a really defining achievement for my husband and I. So I'm a serial entrepreneur. I started my own company, and my current one is actually human resources, focusing on counseling, supporting, and building companies' strength by creating their people's assets and creating strong foundations. So I won't go into the rest of that, but cannabis in the workplace is one of my specialties. I was approached a couple of years ago asking me if I would get involved in cannabis. And at first I thought, but I realized there were no HR experts with cannabis. So I've been developing that over the past few years, and I'm now here to talk to you about it. I have been appearing on some things that are more career focused. So for those in Toronto, I was on CIUT, the sound of our city, and did Career Buzz. I've spoken on the topics of cannabis under Creative Disruption and You're a Millionaire, So Now What? So these are some of my speaking engagements. So let's get to the meat of the matter, impairment and driving. Okay, so this is based on Ontario's definition. Impaired driving means operating a vehicle, whether it's a truck or a car or a boat, snowmobile, off-road vehicles, while your ability to do so has been compromised to any degree by consuming alcohol or drugs or a combination of the two. And so what does impairment mean? Well, impairment affects us as we're doing something. It affects our information processes, our hand-eye coordination, our visual acuity, our comprehension, our judgment, our reaction time, and decision-making skills. So whether it is alcohol or drugs, this is some of the things that affect impairment. And I'll share that again when we talk about work environment. So some interesting statistics. I'll start off on the left-hand side. 50% of cannabis users don't think it affects driving much. And further, a different study said that 20% of cannabis users felt that it has no negative effects. So it's very, very interesting. That's again, different surveys. 39% of cannabis users have said they've used cannabis within 2 hours of driving. And this is a very interesting statistics because when we get into the laws, they've actually picked up on this 2-hour rule that if you are caught impaired with cannabis or alcohol, you are not to drive for 2 hours. So I think it follows this 2-hour rule. And then the last one on this slide is for drug-impaired driving, 3,098 number of reports in 2016 of DID incidents in Canada. That way, right? I think I pushed it too fast. So 2 in 5 people have said they've gotten in a car with somebody who's actually smoked or had some cannabis. And how many of us have done that? How many of us got in a car with somebody who's had, yeah. And of course, if they're impaired, I was driving up with somebody the other day. We went to speak to the First Nations, and he's a chronic cannabis user. And I said, I will volunteer to drive. I'll be the designated driver. And he said, okay, that's fine. 149 number of fatalities caused by drivers who tested positive for cannabis, and that was in 2014. It'll probably go up a little bit higher now that we're legalized. Every 3 hours, there is a offense for impaired driving, and that was a 215 statistics. And the last one I want to share is 1.3 to 3.0 fold increase in motor vehicle accidents after cannabis use. So in June 21st, 2018, Royal Assent happened for Bill 46. Bill 46 is the companion piece to legalization of cannabis. And it is currently in effect. And what it's basically saying, they created offenses in 3 levels. So I get to do the dry stuff, right? The other guys get to do some of the fun stuff. I get to do the dry stuff, but that's my job. So the 3 offenses were first, if you have a low THC concentration of 2 nanograms per ml to 5, the fine would be $1,000. An offense that's greater than 5 nanograms would be $1,000 for the fine, and escalating jail terms for second, third offenses, up to 120 days in jail. And the third offense would be an offense that recognized the effects of the combination. If they found you to be having marijuana and alcohol, then that fine would be the same, $1,000 plus jail term. So note that these new offenses even apply to medical cannabis users. So this is the scary thing, is that what happens, because many of us, as you heard today, we're taking medical cannabis, and we don't know how many nanograms are inside our body. And it could just change by day, so how do you know that? And I know Kevin mentioned to the group, says Hilda will speak on this later. But that is the big concern, is that what is going to happen to those people who are taking it for medical cannabis reasons? There's a hand up.
Just a quick question. Are they checking that like in serum blood levels, or how are they getting those?
They're going to be using an oral swab. So there's a new, I'll show you in 2 slides, but there is a test that the equipment had to be approved by the Attorney General, which was done in August, and some police forces weren't going to buy it at first, and I know in Toronto they just started to purchase some in October. So they've got a few on the go. But good question. So Part 1 also says that the police can conduct tests really only if they have reasonable suspicion. So that might be an erratic driving pattern, or maybe they've spotted something on the dashboard. They pulled you over for maybe driving fast, but they see something on the dashboard. Then they can start to test you for that. So when they do pull you over, they do give you a fine. They do, as I mentioned earlier, requires the individual not to drive for 2 hours. And whether that's related to that statistic that I provided you before. So come next week, 11 days from now, or 12 days from now, on December 18, 2018, Part 2 comes into effect. And this one's the one that's a little scarier, because now you don't need reasonable suspicion anymore. A police officer can just pull you over and just do a random test. And I think the big concern is that sometimes sometimes police might pull you over from a prejudice, racial minority, or the cultural differences perspective. And that's a concern that people are having. And with this randomized testing, now they're allowing them to use these approved oral screening equipment to test for blood levels. And the maximum penalty for impaired driving, 10 years for a first-time incident if it's dangerous, like i.e. you kill somebody or you maim somebody. So down at the bottom here is the nice little Drager drug test, 5,000. I used to remember how much it cost, but I don't know. But it had to be approved by the Justice Minister. So it really went through the rigors of testing, and this is the one they chose. This is the one that the government has approved. And what has to happen is that field officers need to be trained. There are field officers trained in just drug detection, and there are 775 of these experts, but they obviously need to train more if they're catching people. 13,000 officers trained in standard field sobriety tests, and this is Canadian. And what the government is doing is providing $161 million in funding for the police training and drug testing equipment over the next 5 years, as well as public awareness. And I think the public awareness, you all kind of, almost on October 17th, you started to see these ads about, don't drive high, and the youth and cannabis. So manufacturers said that they could supply this Drager test within 6 weeks. And so those are slowly coming on. And I know in Ontario, police forces were saying they were starting to buy this equipment. So I think the concern that I said was, how do you know yourself, if you're taking cannabis for medical purposes, how do you know whether you're going to pass this test or not? And the answer is you don't know, and you're not going to buy one of these Drager tests to check it out.
Sorry, just a quick question on the Drager. How accurate is it? Because I had heard initially when they were introducing it that there were some concerns about its accuracy and its ability to function at sort of extreme temperatures one way or the other.
Yeah, so the question was how accurate is it, and heard questions about the extreme temperatures, as in Canada, whether how accurate it is. They tested a whole bunch of different ones, and this was the one that they felt was the most consistent. And I've heard two various, it's not perfect, right? So, and I think this is why some of the police forces said, there's no way, we're not buying this because you're going to change your mind, or we don't think it's good. It is what it is. It's there, it's the law, whether it will change or not. I think the difficulty is it's there, and the biggest concern are for those people who are taking it for medical purposes. I mean, if it's recreational and you think, okay, I won't do it for 4 hours or 2 hours, then that might be okay. But for those who are medically taking it, then you don't know how high your levels are. Question?
Every medical user that I know, and I've represented quite a few of them over many years, will definitely be over 2 nanograms if they use it on a daily basis. And so, how do you deal with that and the fact that it stays within your system and non-active metabolites go into your fatty deposits and your test presence 90 days later? How are you going to deal with that?
Yeah. So, I mean, I think I heard him very well, so I think everybody heard that. And I think this is the dilemma that many people are facing, and people who are medical users are really concerned about. What I've heard lately is that carry your card with you, so that if you are pulled over, you show it. And they're saying, the police will say, okay, provide it again, and you're not erratically doing something. And they will accept that. But again, it's like crossing the border to the US. They say one thing, but that individual officer may choose to interpret it differently on that particular day.
Because Health Canada, the feds have taken a clear position that this isn't to do with your ability to drive being impaired, but simply that you're over the nanogram level. that's the offense.
Exactly.
Yes.
So I've also recommended to people that they go to places and be tested to determine their various levels, so they can at least present that to the officer on the side and say, look, this is the situation. But you should know that in Ireland, they have exempted people who have a medical registration certificate from it.
So again, I think everybody heard him, and I think, like any legislation, once they hear things, they can backpedal. In human resources, when we had in Ontario fair wages law, and so some of the things as they implemented, they backpedaled on because they realized it was not practical. An example would be they were trying to calculate when you were on stat holidays if you're part-time. And the calculation became kind of hard to do, and it was almost too much in the favor of a part-time person that they said, well, just keep it the way it was beforehand, and now it's been repealed. Paul, James.
Just to follow on to what both gentlemen said, from a CFAN point of view, we submitted to the Minister of Justice over a year ago to adopt a medical defense in addition to the per se numbers. Just as this gentleman really said here, it really is a political issue. They've heard loud and clear. They're not moving on it, and I'm not sure what's going to move them, but we're continuing to advocate there for our patients. It's definitely an issue.
So James is saying they've advocated for, recognizing those people that are medically using it and that their levels would be high, but the federal position is still unchanged. So, as I said, what I heard was that police officers, if you show them, you should be okay again, so provided you're driving properly. I mean, if you're erratic, or you've been in an accident, that's a concern. One of the things you'll find is a lot of challenges. A lot of lawyers will be making money because it will be challenged. And the courts of law will be backlogged with challenges for a host of cannabis situations, and this being one of them. So, as I said here, medical cannabis patients will be in the forefront. And this rising randomized testing really is a concern from those populations where discrimination, particularly against marginalized and minority communities, are there. One of the serious concerns people have is that you can be criminally classified. If you have a serious criminal classification, you can actually be deported because of this. So I think this particular bill is C-46, which was the companion piece to C-45, which was, legalization, is a big concern for people. And the nurse in me says, the problem is, how do you know what your level is, particularly if you're using it medically, or even recreationally, because you don't know it. And it's not like 3 drinks or whatever. It's a number of value which you don't have a blood test to take, you don't have a swab to take. And for some people, when you're in a chronic situation and you're constantly taking some kind of medication, your therapeutic levels are above norm. It isn't the standard person. If the person is taking meds for mental health reasons, or a diabetic is taking certain medications, if you ever took their blood levels, it's higher than the norm. It just makes sense. Or a person who's got joint pain and is taking levels, and they're sober. They're sober because for them it's a maintenance dose. The same amount for a person who's just taking it for the first time would just, have impairment issues. So as James said, it's not about the impairment, it's about a number. And so this is a big concern, and this is why Kevin thought you guys should hear about some of the things that are going on in relationship to this. So I mentioned that $161 billion being placed on education, and I think all of us have seen the education, but I'll remind you with some of the things is, drive sober. Use transit, call Uber, take a taxi, call a friend, do a designated driver, sleep over. So just, make sure that you do something that keeps you from driving high. So I'm going to switch gears now. I'm going to talk about impairment and the workplace. So in impairment at the workplace, how many people are business owners? And then how many people are employees? Just a few. All right. So I want to, when I got invited to become an expert in cannabis, I had 20 plus years of human resources, and this was about a year and a half ago, 18 months ago, and somebody said, oh, we need an HR specialist on our Let's Talk Cannabis panel. Would you be interested? And I'm going, well, I don't know a lot about cannabis, but I do have a lot of experience in HR. And then suddenly I realized, wait a minute, how many people across Canada would have knowledge of cannabis at this point with the legislation in 18 months from now? So I thought, well, rather than say no and then find out they hired somebody who has 3 years of HR experience, says, I can do it, I can do it. I said, fine, I'm in. So I gained that experience, and originally I thought, okay, fine, this is a piece of cake. All you have to do is look for the words alcohol, drugs. Oh, add cannabis, alcohol, drugs, add cannabis. And that's what I thought initially. But as I got involved, the layers of complexity started to happen. And the stigma is there. The fact that people are taking it recreationally and medically are there. So this isn't just any ordinary add-on cannabis. The layer of the stigma and the layer of the fact that you have people who are taking it for medical reasons. And when you are taking it for medical reasons, then you are protected by human rights. And that if somebody says, we have a zero tolerance policy at our company, that I recommend is unwise because it violates your human rights. So no company should ever have a zero tolerance policy because that does not take into account your rights as a human being to be respected, to be able to have a challenge, a disability, and be accommodated for that disability. So under safety challenges, here are some of the things you need to think about. It's sober versus impairment. It's medical versus recreational. It's the duty to accommodate. So the duty to accommodate means if you come to me with a circumstance, and it is, human rights protection, it could be gender, it could be religion, it could be a disability. I, as the employer, have a duty to accommodate you. It doesn't mean that I placate you or you tell me I need to do this. I need 20-minute coffee breaks every hour on the hour. That's not accommodating. That's you dictating as an employee. So you have a duty to accommodate. You have a dialogue, and you balance the needs of you as an employee individual versus the needs of the company and doing the work that you were paid to do. Workplace harassment. So some people may get bullied for either taking a position one way or the other. When I talk about human resources and cannabis in the workplace, I ask everybody to close their eyes for a minute. So please, close your eyes for a minute. And then think about that word. When I say weed, when I say pot, when I say cannabis, what does that mean to you? Do you have a good feeling of maybe when you were younger and you were high? Do you have friends? You're thinking of a party? Are you a parent and thinking, oh my God, I'm so worried with Johnny. He's going to be exposed to all of this cannabis and terrible stuff. What does that mean to you? So just open your eyes. Now this audience, you're coming because you're interested in cannabis. You're probably good about that. But some audience, they have such a visceral gut reaction. And what I do is I challenge people is that if you're a manager and you had a very negative reaction and an employee comes to you and says, I'm on cannabis for medical reasons, and you want to have a discussion about accommodation. If that person says, there is no way that you are having to have pot in my company, out the door, you're fired. And that's not what the policy is. Imagine what that does to a company's brand. Imagine what that does to human rights violations and a legal case. So I always ask people to take that stand because as I've gone along, I've learned and I've been exposed to a lot of people who I'll call colleagues and friends now. And when they tell me their story is about, today I'm functioning, I'm doing things, I really feel good about myself. But 2 years ago, Hilda, I was in such pain, or I was so depressed from other situations that I wasn't functioning. I couldn't get out of bed, 6 months in the house, and that's all I was doing. And when you hear these stories and how it changed their lives, it makes you realize that, you know, we need to come from a place of, as Dr. Helping said, of discussion, of learning. So when I talk to people, I have a discussion and I help them come to a neutral place at minimum and be respectful of who they are working with. So discrimination can be a concern. Safety risk, biggest concern. You know, how many people came on a plane? How many people were worried that that person might have been high? Well, certainly your travel, your airplane company, I chose Air Canada, would have put policies into place to make sure that people were sober and that whatever policies they had, those people in what I'll call safety-sensitive positions were going to be okay. Health and safety, occupational health is important, and it's part of the policy that has to talk about cannabis in the workplace. Work performance. Now, people will say work performance is a big concern. And I challenge people to say, before cannabis was legitimate, there were probably many people in your company that were maybe your star people, and they were on medical cannabis. But they didn't have to declare, and you didn't have to know. But now that they know, how does it change your thoughts on them because of the stigma? But it doesn't change their work performance. So there's a distinction between performing well and being impaired. And so work performance is a concern, but not a concern at the same time. And the legal impacts, which I'll talk about a bit later. So, as I said, there is that balance from an employer's perspective of accommodating and protecting from discrimination versus safety of your employees and your coworkers. So the definitions, impaired at work, there is really no formal definition of it. I had trouble finding it, but the closest thing was the Canadian Human Rights Commission says it's the appearance of alcohol or drugs or glassy or red eyes, unsteady gait, slurring, and poor condition. Like, that's poor coordination. That's not a definition. But again, I searched and searched for a definition and could not really find one. For disability, though, the Canadian Human Rights Act says any previous or existing mental, physical disability and includes disfigurement and previous or existing dependence on alcohol or drugs. Question?
So, with the duty to accommodate, this is a question that I get quite a lot, especially with new companies that are setting up. Isn't it correct that a medical patient doesn't actually have to disclose to their employer that they're a medical patient, and that if they do disclose that they're a medical patient, they also don't have to disclose what exactly they're taking? So that seems to be a big problem where this is concerned, because there's a duty to accommodate employees who are medical patients, but if you don't actually know that they're a medical patient, you're not allowed to ask them. And if they do disclose it, you're not allowed to know basically what it is that they're taking and in what sort of dosages. Are they high level of THC? Are they CBD? You know, you're not allowed to ask those questions. So how do you face that in the workplace?
So I think everybody heard that, because I heard that clearly. It's a very good question, and later. But every company should really examine their policies and determine what your policy is, and then clearly communicate that to your staff, educate your managers, and then follow through on that. If you do not have a policy that asks people to identify for a medical, that they are taking it for medical reasons, then if something happens, you can't fall back on the fact that you didn't know because you didn't have a requirement to know. But if you put it in your policy and said that everybody who is medically using cannabis, we would like you to come forward because we want to accommodate. Say it in a nice way. If they don't come forward and do so after the fact of an accident, and this is one of my legal cases, then that employee does not have a leg to stand on, because you told them this was the policy, they didn't do it, they had an accident, you have grounds for doing something. So whatever it is, every company needs to define their policy, and I'll kind of spend a little bit more time on that as well.
So, but is it just for cannabis, or every drug has to be declared? Now I'm curious.
It's really about, well, everybody has a duty to accommodate. And in the case of non-chronic conditions, you don't necessarily have to. But in the case of medical cannabis, you can choose to ask that. Because...
So not for benzodiazepines, not for opioids, it's just medical cannabis. Interesting. Okay, thank you.
Yeah, I didn't know that was for medical cannabis. I thought that it was illegal to ask anybody to disclose that. That's there, and that's where discrimination can come on board, especially for people who have mental health issues. I thought from a legal standpoint, you can put that in.
If you put in your policy that you want to know this, then that is the company's position, and they can use that against a person that didn't declare.
So what about discrimination just because you're asking that question? Technically, it's about compliance, and a doctor-patient confidentiality cannot be broken.
So the question, just in case people didn't hear it, what about the discrimination piece? And it's how you handle a situation. You know, it is, when a person comes forward, it is in confidence, and it must be treated in confidence. Except, obviously, if you need to share that with people, if it's a safety-sensitive position, and you're going to say, well, he's allowed to take so many breaks a day because of whatever, you have to let the manager know that. Otherwise, the manager's going to think he's slacking off, right? So there's a fine line. But again, I always say is that when you work with people, you need to be respectful. And if you create a respectful environment and you handle that situation in confidence to the point that I shared just recently, as well as respectfully, then it's a tricky slope.
Clonazepam need not be declared, and you cannot ask about clonazepam, but you have to ask about medical cannabis to avoid liability. It's not a sense.
You make it sound black and white. It's gray, okay?
Yeah,
and I think we've already heard about how opiates is a double. It's a double standard, dual sword thing.
Yeah.
This is no different, right?
John, can I just? It seems to me that it's a bit. It could be described much clearer than that, because a lot of companies request information that one, they don't have a right to, and two, there's no need to know. If you're within a particular type of work and your output is X, and if your insurance liability wants to ensure that that individual in that displacement of that particular job in that X poses a risk if that person does not do the job in a particular way, then there will be a cause for the company to take a course of perhaps doing random checks just in that particular instant. It cannot be a wide thing. I mean, as a lawyer, I cannot see how it's possible. So it seems to me that it has to be that the employee is conducting a particular piece of work, whether it's by insurance purposes or a health and safety issue. That person's scope and state of mind or whatever it is need to be ensured in order to remove the company's liability for that particular piece of work and the way it's conducted. But it cannot be that you just ask any question for one. The same way you cannot ask somebody's age, their religion, all those things you do in an application form, which was done for years. When challenged constitutionally, you can. It's the same thing about the point before about the issue of the police stopping you and taking whatever test they want. Constitutionally, you have a right for the police to give you a sample of whatever it is that they're using to try to convict you. You can use any of it and all of it to defend yourself. If they don't, you're off the case. It's done. Yeah. So there's always this legal balance of when we challenge these things. I mean,
Right.
we know all those bloody silly cases they bring in this kind of thing. Because they fail to provide you with, they have to give you a sample of the evidence they're using to convict you. It's called equality of arms. Every single jurisdiction uses it. You have some sleeping lawyers that don't apply it. But every time it is used, the police always forget to give you that sample, and then the case is done. So it's not, it's not an issue.
Why did I not get the jokey ones? Why do I have to be like, whoa? I should not have entertained any questions. I think your point is valid. As a company, you can't just sort of say, well, we'll just let it go for this, and then now we're going to apply it here. Sometimes companies have to have some kind of position statement that kind of balances risk with retention of staff. So not to say anything and then to create something after the fact is probably not prudent. Can I just keep going? I know I'll entertain it more in the Q&A period, because I haven't even got to the examples yet. Okay, safety sensitive positions. So these are the positions where the safety of either your co-workers or your public are at risk. And these are the ones, and I'll use that terminology later, safety sensitive positions is where you want to make sure that your policies reflect safety. So there's no one definition, but here's one, is that if not performed in a safe manner, can cause direct or significant damage to property and or injury to employees or others around the public and an immediate environment. And I'll give you the case of the TTC to show you about a safety-sensitive position. The other one is called a bona fide occupational requirement. And so this is where you say, I'm going to apply the rule. Instead of to everybody in the company, I'm only going to apply the rule of declaring that medically, if you're medical use, you need to declare it for bona fide occupational requirements. And what that means is that this particular job area is so of a concern to me that I need to do something specific. And when you can apply this rule, because there was this a case called the Myorian test, I don't know how to pronounce it, and what the court says is that you can create this bona fide requirement if you, one, establish a rational connection to performance. So we all agree that people who are flying our airplanes should be sober and fly. So I would like to know if I need to medically accommodate. Number two, honest and good faith belief that the standard is really necessary. So you wouldn't apply it to the receptionist, because that doesn't sound fair. That sounds like, the ant and a big fly swatter or a gun to shoot an ant. And it's reasonably necessary. So that's the BFOR in Canada. Other countries have similar jurisdictions. So again, what is impairment? Again, there's a difference between sober and impaired. And again, all of those criteria that we had stated for driving are the same things. Your visual acuity, your hand-eye coordination, your judgment, your ability to prioritize, all impacted. And then there's the physical aspects that people see, and then the workplace aspects. So physically, people might be sweating, they might have diarrhea, they might have headaches, slurred speech. Those are the obvious things, but at the workplace, what are some of those other signs? People are taking a lot of sick time, they're taking a lot of breaks, they're forgetting things, they're having more errors in their judgment than usual, and a host of other things. But the quality of their work is a concern to you as the employer now. So I'm just kind of giving you all these so that when I give you the examples of of legal cases, you understand where things are coming from. So a little bit about safety-sensitive positions. It's, as an employer, would have a duty to inquire. And the way to do that is from a discussion, to use Dr. Hepburn's comment, is have an open discussion. Say, hey John, I've noticed lately that you've been late a lot, the quality of your work's not up to your usual performance. What's going on? So again, being very objective, and he might say things that will help you to say, okay, what can we do to make you get back to that level? So you don't just ignore people who are not performing, you address it. And you do have a duty to inquire. Then there's the duty to accommodate, which we had already talked about. And I talked about it earlier about setting those policies and procedures. It's very interesting. A couple of companies, I just want to make sure we have enough time here. Okay, 10 more minutes. A couple of companies, very interesting, both licensed producers. And one person said, okay, some of our staff go out to client events afterwards, and Cannabis might be part of the food choices or non-food choices. And what they said is, we give you permission be able to partake of cannabis. And they put that in their policy. Another licensed producer said, you are a brand ambassador of our company, we want your game on, we want your game face on, so we don't want you to take a little bit too much. So no, 0. You are not allowed to partake of any cannabis during events where you're our spokesperson for our company. 2 companies, same industry, 2 different positions. What I'm saying is that what you need to do is identify what your policies are. That is an example. Whether you want to disclose and have that duty to accommodate, you need to identify that. So some companies may choose to decide not to say anything and stay silent on it. Again, if something happens, that policy you created will be used for you or against you. And then recreational. It's very interesting. One company that I talked to was very silent, and then on October 17th, they issued a 1-pager to tell people they can't smoke and they can't take cannabis recreationally. And they said, that's it. No training for managers, no explanation for the staff, just expected to read this and follow it. So to me, you really do need to create your policies. You need to make sure your managers are trained in interpreting those policies and that staff know about them. So a couple of legal cases to wrap up. I'm part of International Cannabis Solutions as well. I am the HR expert, and we do have a legal expert. So these slides, next slides, are with permission of Mario Torres, who is with Brazo Seller, LPP, based in Ottawa. So the first case is the ATU, which is the Union for the TTC in Toronto, the Public Transportation System, and the TTC. So the TTC decided to create a policy with regards to alcohol and substance abuse, and in that policy, they were going to go to arbitration because the union challenged it. But within that policy, they actually had one for randomized testing of alcohol. And so they actually put an interim motion in place saying, okay, we understand you're going to arbitration, but we want this random testing to stop. And so we're going to create this interim motion and challenge this. So that went forward. The management felt that they need to balance the rights of the employee with the management, and so it went to court. So what the TTC claimed was this is public safety and in the interest of public safety. 1.8 million people use the TTC every day, and they had a culture of on-the-job alcohol and drug use. TTC said, we don't know whether when they are impaired, what to do, because we don't have a way of detecting and verifying incidents. So we got to do random testing. And the nature of the drug tests, and this part is important, is that they did an oral fluid swab. So it's a non-invasive, they're not poking you with for blood. That the test was conducted and the results were done through third party. So it wasn't TTC managers or occupational health nurses doing this. That you had 2 saliva samples taken, and the person had the right to challenge or explain the failed test. When the test was designed to detect impairment and not the use of the drug. And the third thing is, if you were found to have failed the drugs, they did offer you treatment following that. So in actual fact, it's a very humane way to do it. Non-invasive, I give you several tests to try it, and if you fail, I give you support for your situation. And I allow you to explain why this might be. So the judge denied the union's motion and refused to issue an injunction. The judge said random testing will remain in place, and that it favored allowing this random testing. And the takeaways from this is the judge accepted the test of impairment with respect to cannabis because the amount, they actually were allowed 10 nanograms. Remember, driving 2 to 5 and greater than 5 was reasonable. and that the ingestion of cannabis in the last 4 hours was accepted as a demonstration of impairment. Not the one that the government had, but you can see this is even, you have a bit more time. The workplace, the nature of the work, and the risks were considered in this decision-making, and the way they did the testing, which I think was very fair, more than fair, rather than one strike and you're out. The next case is Stewart versus Elk Valley. So the employer had a no free accident rule within its substance abuse policy. So if you have an accident, it's grounds for dismissal or discipline. Disclosure of addiction, a dependency prior to any accident would result in the employer-funded treatment, and then non-disclosure or result would mean you'd be terminated. So they basically had a policy that you needed to tell them, and if you didn't tell them, then you were in trouble. You could be terminated. So Stewart was occupying one of those safety-sensitive positions. He had a cocaine dependency, which he did not share. And he didn't use it at work, but it would be in his system. So he did have a workplace accident. Fortunately, nobody was injured. And Stewart was tested for drugs, and he failed the test. After he failed the test, he disclosed that he had a dependency, but he was nonetheless terminated. So what happened here was Stewart argued that his dependency, the inability to recognize a dependency, was grounds for why he didn't share that, because he didn't know he had an addiction, was what he said. But the Alberta Human Rights Tribunal found that the Stewart employment was terminated for failure to follow the policy, and it was not due to his dependency. So this was not a case of discrimination, because he did not declare that he did not come forward and declare he had a dependency. So this went all the way up to the Supreme Court. Both upheld the decision because he violated the workplace policy, not the drug part. So this case is really important because even though it's not a cannabis decision, it applies the principles. So this is what I'm saying. You can choose not to have a declaration policy, but this will come back to haunt you if you don't. So the takeaways: policies must be carefully drafted and applied. The disclosure of issues related to substance abuse will trigger the human rights protection, for sure. And disclosure dependency of an accident is unlikely to prevent consequences of not complying with the rules. The last case I want to do is IBEW 1620 versus Lower Churchill. So this one was where a person was terminated with a valid medical cannabis prescription. So the griever had medical cannabis prescription for chronic pain. And he worked at Hydro, where employees resided in a dry camp for 21 days in succession. The griever brought his legally obtained cannabis to the camp. Management noticed an odor, and he then said, well, I do have prescription, and I use it for nighttime use. The griever remained on the job for 5 days afterwards, but was terminated. The workplace policies contain zero tolerance language regarding drug use. So the griever then took this to the Human Rights Tribunal. The griever did not disclose his cannabis was used prior to his start of the company, and he would always just stop before he got tested, and he would pass his test. There was never any evidence of work impairment, which is important. So what happened here was the union argued that the termination and the zero policies were discriminatory, and that the duty to disclose was a breach of the griever's privacy rights, which somebody already said. So, I mean, these aren't ironclad, right? These are very, very new laws which will be open and subject to our perceptions and our challenges. The employer argued that the zero tolerance and the duty to disclose were bona fide occupational requirements, which I said before, because of the nature of the workplace and the safety. And the union also argued that the termination was an unreasonable penalty. So this one was actually, the court found that the arbitrator did not engage in insufficient analysis to justify the termination. So the court actually asked them to go back and re-examine everything. So this is inconclusive, but the court did cite that in the case of the city of Calgary, an employer had disclosed his medical cannabis use and was accommodated, even in a safety-sensitive position. What I'm trying to do is say to you, there's lots of challenges going on. There is no black and white, and it is it's very interesting. I think when you hear the cases, I find it helps me figure out what kind of policy I want to do, because it's all about risk and it's retaining staff. You want to make sure that when you create policies that, yes, the employer wants to make sure he minimizes his risk, or her, but you don't want to turn off employees so that they won't ever come to work for you because it's too one-sided. Any questions?
What years are those cases?
Are
they still before the courts?
Well, this one is still pending, and the other two, well, the one went to the Supreme Court of Canada. I think it's only like a couple of years ago that it was decided. So they're all fairly within the last 2 to 3 years. The TDC very recent, like within the last year or two.
Still going through the court process. The other two that didn't go to the
The TDC, the randomized was determined to be fine. I think the actual whole policy is still not finalized yet. And the other one went to the Supreme Court of Canada. This one's still being assessed. Okay. So the takeaways here: employers have a duty to accommodate upon disclosure, and the ability to perform duties safely will be a significant factor at all times. But the onus is for the employer to prove that that is a bona fide or a safety-sensitive position. Workplace safety is number one, and you'll find that companies like the airplane companies really took to heart and created their policies regarding the impacts of cannabis in the workplace. Yeah.
I was just going to say the impairment's different for everybody, especially medically, and you have people in positions who may not understand. You can see we're opening up a big can of worms for lawyers and human rights, because how you react to it's going to be different to how I am. And maybe during the day I have a high CBD, low THC, but you don't know that as my employer. You may just assume that I'm high on THC anyway, so it's a good conversation to have with a lot of layers.
And I challenge companies who just kind of kept their heads buried in the sand and have stayed silent on it. You've got to have a conversation. You've got to communicate what your policies are, because how do I know that I'm breaking the expectations if I don't even know what your expectations are? So this is why you have to declare something and share it so that people know what they can and what they can't do.
What responsibility is on the employer to be educated about cannabis so that they realise that cannabis is very different to cocaine and all those kind of things around impairment, about safety? It's a really very different thing, as we know.
So what onus is it on the employers to get educated? And anybody who runs a business needs to be educated on all aspects of their business, right? And that's the sad thing, is I think too many companies sort of say, well, I don't have anybody in my company, I don't have to do anything about it. Meanwhile, they don't know, because they don't know. It's like mental health. People don't know how many of us are walking around with a mental health condition, and yet we're at work every day. So it is a stigma, it's something. Every company should get educated, but not everybody will.
But there's too many assumptions that, we block it in as being the same as drugs and alcohol, but it's a very different thing. And so many people don't realise that.
I think what your point's well taken. People don't know a lot. And I think those that you come today have a genuine interest in hearing more. And I think the speakers before me really talked about that there is a stigma, and how do we kind of work with that stigma. And I think Dr. Hepburn said it really well when he said, have a conversation. Don't make it a dogfight. Have a conversation and educate people. Whenever I sit down and I kind of casually say that I do talks on cannabis in the workplace, and when they hear about it, they say, wow, that's really interesting. And so little by little, I'm educating people one-on-one in larger groups. I spoke to a senior citizens group, and one of the things that was funny, I'm talking about, checking in with your gut and change. And I think as a mother and a parent and with parents, I always worry about that, my grandparents and my parents. I don't want to tell them that there's gender identity issues in our family. I don't want to tell them there's a mental health, because I want to preserve that. And as I'm talking to the seniors group, I think, so wait a minute, this changed. This is a piece of cake for you. You've been at this for years, you know, your prohibition when that came. And one of the older ladies in the room said, yeah, that was rough. So I think it is about change. This is what we're doing. We are pioneers in a change, and the change is the stigma. And a year from now, 2 years from now, this is going to be norm. And I think the word is out there. You read a lot about it. So some employers will start to understand, or if they're touched by somebody. I was at an event where my staff from my previous company had come to a gathering, and I told him I was starting to talk on cannabis. He said, who would have ever thought my boss's wife would be speaking about cannabis? And that just blew his mind away. And then he said, you know, my uncle is a pastor, and he has chronic arthritis, and he's been on cannabis that really helps him. But he will never, ever tell his parishioners, because there's a stigma. So this is the kind of thing that when you hear people, people will start to get educated. So more and more we're going to have those conversations, and more people will make changes. I think I only have time for maybe one more question.
Would you suggest if a patient is a medical or a recreational user, say they're an occasional recreational user, do you think they have a duty to disclose the fact they do so? Because they could be saliva tested 3 weeks later and show that it's present.
So if you're recreational, do you have a duty to declare? You only have a duty to, well, you don't have a duty to declare unless your company asks you to do that, but it is the medically one. If you're taking it for recreational purposes, I have no duty to accommodate you. It's only when you have a medical condition, it's a disability as defined by the Human Rights Commission, that I have a duty to accommodate you. But some people will challenge you to say, if you're a recreational user and you use it every weekend religiously or every evening to take the edge off, maybe you are using it medically to help you with stress. And so that's the challenge some people have.
Do you have any advice for the RCMP officer who isn't allowed to use it for 24 hours
Oh my
before
God.
coming on duty, whereas the Vancouver police officer doesn't fit for duty?
Or the ones that have to wait 28 days before they can do it? Like, I don't have any advice. And I'm glad I'm not asked that question, so I'm going to refuse to answer it. I hope that this talk has really helped you think about some of the implications as we are living in a legitimized world of cannabis now. And it begs things, because you are individuals who you're either employees or you're an employer, or you're a user, or you're driving. And so we all have decisions that we're going to make. Like the one I made, thinking, if we get into a car accident on the way up to the First Nations, I'm going to drive because I don't want to worry about that, because I can just see my family saying, you got into the car. So I drove 2.5 hours. I drove. Thank you very much.